What were the framers worried about?
Power.
Power. Too much power. Power that threatens liberty, democracy. Notice the phrase, the judiciary has no influence over either the sword or the purse. What's the sword? Executive?
The military.
The military. What's the purse? The money. The most important things are who's got the guns and who's got the money. The courts don't have either one of those. They're limited. Their power is limited. So they're the least threatening of the branches of government. There are checks, there are practical checks on judicial power. The Supreme Court has to wait for a case to come to it. Do not assume that laws pass Congress and go over to the Supreme Court to be stamped constitutional or unconstitutional. That's not how it works. Laws pass Congress and they go into effect. At some point, somebody affected by the outcome of the law may file a lawsuit, and then that lawsuit goes through the process. Remember all that ladder of courts? Goes through that ladder of courts, and it may reach the Supreme Court, and then the Supreme Court can rule on that particular controversy. But that's maybe years down the road. Maybe. And no case may reach the court. So the judges can't sit around and say, well, let's do this, let's do that, let's do this. They have to wait for a case. The court is reactive. It doesn't make policy. It reacts to policies made by other units of government. If the court interprets a law, Congress and the President can rewrite that law. If the court decided that the Affordable Care Act was unconstitutional, if they wanted to, probably they wouldn't have, but if they wanted to, Congress and the President could have rewritten that law to deal with the objections of the court. They can amend the Constitution. This is really hard to do, but in American history it's actually been done a few times. Decisions do not enforce themselves. The Supreme Court does not have marshals. There is not a Supreme Court police. We're going to study next week the Supreme Court's decision about government-sponsored prayer in schools. If you decide to pray before the test on Thursday, that's your prayer, and that's perfectly legal. However, if in the public school down the street, the teacher decided to lead the students in the Lord's Prayer or some other prayer before class, the Supreme Court has said that that violates the First Amendment of the Constitution. It's a government-sponsored prayer. Let's suppose that there's a small town in Texas where there's a teacher actually doing that. What's the enforcement? Are there federal marshals that monitor what teachers do every day in school? Yes, sir?
The child goes home and tells, mom and dad what happened during the day in school, and mom and dad go to the school and say you can't do this, and they don't change it, so they take it to a lawyer, and the lawyer files, a suit against the school district, right? And then it makes its way through the judicial.
Or it may not have to go all that far. But yes, that's exactly what would have to happen. You would have to have somebody complain, and then if the school doesn't respond, then somebody hire a lawyer or go to the American Civil Liberties Union, which may volunteer to help you, and file a lawsuit. And the lawsuit be heard by a court. Now what I've described is probably not go very far because that's pretty clear cut. But you also have remember we talked about in East Texas with the cheerleaders writing Bible verses on the paper that the football team runs through when they go onto the field. You had several families that challenged that, and that case is still working its way through the courts, I think. Initially, the school won because the argument was that it was expression by the cheerleaders rather than the school. You can pray. I can't give you a prayer to pray.
In any part of the school?
Well, you can't be disruptive. There's time, manner, and place. If you decide, let's say this is high school someplace, and if you decide to interrupt my class by leading the school, by leading everybody in prayer, you can get in trouble for that. But if you're saying grace over lunch or something, that's perfectly fine. You can't disrupt the school. You wanted to disrupt the school. Yes, ma'am.
I have a question. There was a girl that came to us for student government, and she was Muslim, and she asked us for a place to pray for on campus. So what we told her is that the school can't really associate itself with, the religion.
I think if you wanted to, you could probably say there's a room over there you could use if you wish. I think that would be constitutional. That would probably be a nice thing to do. I don't think you can get in trouble with telling, there's this room that's vacant if you want to spread out your rug and prayer cloth and do it during a time that's not between classes or something like that. So I don't think there's anything wrong with that at all. Now, if you say we can't do it, I'm not sure that you can be forced to do it. We'll kind of talk about that next week, actually. The ultimate check on the judiciary is the appointment process. The Supreme Court today is closely divided between two blocks of judges. You have a set of conservative judges. Conservative judges tend to favor the government over criminal defendants. They want to narrowly interpret guarantees of equal rights for women and minorities. They support corporations in dispute with consumers and workers. And they rule against the federal government on local policy issues. In contrast, liberal judges are more inclined to favor the interest of underdogs, such as consumers and workers and criminal defendants or members of minority groups. They tend to support the federal government in federalism disputes with states over the relative power of the national government and states. Our court today is deeply divided between a liberal bloc of 4 justices, Ginsburg, Breyer, Sotomayor, and Kagan, and a conservative bloc of 4 justices, Thomas, Scalia, Alito, and Roberts. What do these liberal judges have in common? Appointed by Democratic presidents. What do the conservatives have in common? Appointed by Republican presidents. Notice, have I left something out? There's only 8. 4 and 4. The most important man in America. Who is this? That's not President Obama. That is not President Obama. That is not the first African American president. You were doing good with that little line for a while.
No, but I mean, that's the most important person.
Kennedy. Anthony Kennedy. Anthony Kennedy is the swing vote on the court. When the court splits 5-4, 4 liberals, 4 conservatives, when it splits 5-4, which is often, he's the number 5. He's conservative, but he's not consistently conservative. His vote, more often than not, decides the outcome of cases. This year, there were 3 major cases that I had your predecessors write about last spring. One of these cases involved affirmative action in higher education. This was a University of Texas case involving a young lady, Abigail Fisher, from Sugar Land, I believe, who sued the University of Texas. She's white. She said that she was not omitted because that other students who were African American or Latino were let in who were not as well qualified as she is, and they were let in because of an affirmative action program at UT that made being minority a plus factor in admissions. She sued, charging that violated the U.S. Constitution. The court gave a sort of muddled and indecisive decision, but it was 5-4. He was among the 5. There was a Voting Rights Act case in challenging the constitutionality of the Voting Rights Act. And the Supreme Court found a significant portion of that act unconstitutional. The vote was 5-4. Kennedy was with the 5. So he was with the conservatives. Then finally, there was a case involving the Defense of Marriage Act, same-sex marriage. This was a federal law that defined marriage as only between a man and a woman. So the case itself involved a couple from the state of New York where same-sex marriage is legal. One of the partners died and left a nice estate to her spouse. The federal government taxed that as if it was a regular inheritance. Had they recognized them as a married couple, there would have been no inheritance tax on that. The Supreme Court ruled that the Defense of Marriage Act was unconstitutional because it was treating legal marriages differently, whether they were same-sex or traditional marriages. That was a 5-4 vote. Kennedy was in the 5. So the 3 most important cases last year were 5-4, and in each of those cases you had 4 liberals, 4 conservatives, and Kennedy was going back and forth between them. And my favorite line, it's Anthony Kennedy's world, the rest of us just won't.